The Essentials of Eviction for Renters and Owners. American Advantage Law Group, 3848 Campus Drive, Suite number 206, Newport Beach, California, 92660. Disclaimer. The materials available at this website are for informational purposes only and not for the purpose of providing legal advice. You should contact your attorney to obtain advice with respect to any particular issue or problem. Use of and access to this website and or any of the email links contained within the site do not create an attorney-client relationship between American Advantage Law Group and the user or browser. The opinions expressed at or through this site are for the opinion of the individual author and may not reflect the opinions of the firm or any individual attorney. Eviction. Landlords cannot simply lock tenants out. There is a multi-step and complicated process that individuals, landlords, and tenants must go through in the eviction process. It is required that landlords terminate the tenancy before eviction, and this is often required to have a written notice, depending on state law. Furthermore, landlords must file an unlawful detainer, or UD, at the beginning of the eviction process. State law. Each state has a different and unique law regarding the processes which tenants and landlords must go through in the process of eviction. This dictates all facets of eviction, including the termination notices required and the eviction papers that the landlord and tenant must file. If not followed correctly, this misfiling of these papers can cause problems with the evictions for both the tenant and the landlord. Types of termination notices. Pay rent or quit notices. These are the most common and most obvious. If the tenant does not pay the rent indicated on the lease agreement, the landlord is basically asking him to either pay the rent that is due, or quit or leave the premises. Cure or quit notices. This is in the existence of a violation. The landlord asks the tenant to either cure the problem that is occurring based on what is said in the lease agreement, or quit the premises again. There's a set amount of time that can be determined based on the lease agreement. Unconditional quit notices. These are only allowed in certain conditions and basically say that there's no way that the tenant can remain in the premises and must vacate them. These can be allowed if the previous two are pre-existing, for example, a combination of a problem with the lease agreement and lack of paying rent. Notice of termination without cause. These are exceptions to termination notices and often do not require any notice except for the eviction notice. Generally, a 30-day or 60-day notice to evacuate is required, depending on the state law. But rent-controlled cities often do not allow this and require a just cause eviction protection, basically saying that the reason for the eviction. Some states follow this protocol, including New Jersey. Eviction lawsuit. Following the receipt for a termination notice, the landlord must properly serve the tenant with a summons and complaint for eviction, based on state law as well as federal law. Often the outcome of the lawsuit comes down to extenuating circumstances, and the tenant may often find his way out of a lawsuit based on the behavior and paperwork filed by the landlord. So it is crucial that the landlord file good papers in all processes of this eviction. Local law enforcement will be charged with removing persons and items from the property if the landlord wins, and will pay a fine to do so. This has been a presentation of American Advantage Law Group, 3848 Campus Drive, Suite number 206, Newport Beach, California. Our real estate seminars are held 1 p.m. Pacific Standard Time every Wednesday. Again, the disclaimer, the materials available at this website are for the informational purposes only and not for the purpose of providing legal advice. You should contact your attorney to obtain advice with respect to any particular issue or problem. Use of and access to this website or any of the email links contained within the site do not create an attorney-client relationship between the American Advantage Law Group and the user or browser. The opinions expressed at or through the site are opinions of the individual author and may not reflect the opinions of the law firm or their individual attorney.